This one's going to move fast because this courtroom just exploded. In today's case, we have a defendant who, according to the record, picked up a felony on October 17, 2024, and just 3 days later allegedly threatened to shoot someone, then evaded officers twice by about 12 yards before being cuffed. The judge, she's not here to play. From revoking bond on the spot to threatening $2 million bail if needed. She's drawing a hard line. Public safety first, excuses later. We'll break down what a terroristic threat actually means when no gun is found, why PR personal bonds and repeat arrest cases make judges absolutely lose patience, and how something as common as THC in your system can land you right back in custody when you're under bond conditions. Plus, the defense pushes back hearsay, lack of an evidentiary standard, and due process concerns. Is the judge overreaching, or just doing what it takes to protect the public? Stick around, because this case is a perfect storm of anger and accountability. And by the end, you'll have a crystal clear view of how close this defendant came to losing his freedom entirely.
And I'm going to tell you now, I'm not going to have you, and I'm not going to stand for your threatening anyone in this court at any time. That is, every part of this is an extension of us. I don't care where you're going. I don't care what building you're in, whether you're in pretrial services, whether you're taking a drug test. It's unacceptable, and I'm revoking your bond. And he now goes with you.
Yes, sir. No, sir. Arms by your side. All he's doing is setting the rules that you're going to follow.
Right out of the gate, the judge plants the flag. Threats against anyone tied to the court equals zero tolerance. That's not just tough talk hits, legally grounded. Judges can revoke bond if they believe a defendant poses a risk to public safety or is violating bond conditions. Remember, bond isn't a right to roam unchecked, it's conditional freedom. Here, the judge doesn't care whether the defendant is in pretrial services, a different building, or taking a drug test. The message is universal: behave or sit in custody. Question to you: was the revocation justified at this early stage? Or should the court have waited for a formal evidentiary hearing first? Drop your thoughts below, because this line, "I'm not going to stand for your threatening anyone," sets the tone for everything that follows.
Okay.
Yes, sir.
What's the name?
Bledsoe. Evading arrest and terroristic threat. He was in custody because he had a pending felony in the 228. So he's bonded out on all. The evading, I think, is 12 yards per the officer.
So I see that on 10/17 of 24, he picks up a felony assault. And 3 days later, he picks up a terroristic threat, and then he picks up an evading arrest. And they give him PR bonds on these cases. Is that what happened? And
he bonded out since his last setting. I didn't check to see if there were PRs or not, Judge. I know that he had to pay money in felony court.
yeah, it's just, I'm not down with PR bonds on this. I mean, he picks up 2 new cases if it's the same. Well, hold on a second. Let's not get ahead.
Now we move into bond math, and it's messy. The judge is clearly irritated. Felony on October 17th, followed by a terroristic threat and evading arrest. And some of those bonds may have been PR. A PR bond means you're released based on a promise to appear, not cash. Judges hate granting PR bonds when it looks like the defendant is stacking cases in quick succession. But the defense draws a technical line. These aren't new cases there, the due cases filed after the felony arrest. That matters procedurally, but optics and risk matter to the judge. For viewers, do you think multiple arrests in a short window should automatically trigger higher bonds, or should each case stand on its own until proven?
When he got a bond in October, how on earth is it?
He was in custody, I think, on the felony.
Oh, I see. Okay, and then he bonded out of the, right, okay.
Yeah.
Got it. All right. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please, what happened?
On October 19, 2024, officers dispatched to a minor crash at a residential home in Harris County, Texas. The call described a male at the location crashing his motor vehicle, then pulling a gun, and was trying to fight people at the location. When officers arrived at the location, they observed people at the location pointing at the defendant. Upon contact with the defendant, the officers introduced themselves as Houston police and told them to stop. The defendant then walked into his residence and came back out approximately 2 minutes later. The officer instructed the defendant to come towards them, but the defendant began to evade on foot from the officer the second time. The defendant ran approximately 12 yards from the officer.
Let's decode the probable cause recap. Police respond to a minor crash. Witnesses say the defendant pulled a gun, threatened to shoot and kill, and reached into his waistband, classic indicators of a terroristic threat charge, even if no weapon is ultimately found, legally, for a terroristic threat. The key element is whether the complainant reasonably feared for their life, not whether a gun is recovered. Then there's the evading. Running 12 yards may sound small, but distance doesn't matter. Intent to avoid arrest does. The defense is going to lean heavily on no gun, no assault charge, but the threats plus fear standard still holds. Audience question: if someone threatens you with a gun you never see, should that still be a criminal offense if you felt genuinely threatened?
Something perfectly clear to you. I will do everything in my power to protect my public at all costs. And I don't care if I have to make your bond $2 million. I'm going to do everything in my power to protect my public at all costs. Do you understand? I don't care who you are. I don't care where you come from. I don't care what, nothing. I want my county safe. You will be signing an affidavit with me today, promising me that you're not going to have any weapons whatsoever. And if I find that you have a weapon, I can have a contempt hearing. You're looking at 180 days in jail every time if you're caught with a gun. Do you understand? I'm sending you now for a drug test. I want to know what, if anything, is going to be in your system as well. I'm ordering you not to use alcohol or illegal drugs, and I'm going to test you like crazy. Do you understand?
Yes, sir.
What do you do for a living?
I work for Leland Airmark Bakery.
Okay, that's what you need to concentrate on. Working a lot so that your time is occupied. When you have too much time on your hands, you become self-destructive. Do you understand?
Yes, sir.
Do
You're
you
right about
have?
This is a judicial clampdown in real time. The judge orders an affidavit, no weapons, no alcohol, no illegal drugs, plus random testing. She warns of contempt up to 180 days in jail every single time he's caught with a weapon. That's critical. Contempt is separate from bond revocation. It's a direct punishment for disobeying court orders. She's also telling him to work, stay busy, and avoid self-destruction, which, believe it or not, is a strategic public safety message. Structure reduces recidivism. The subtext is stark. I will protect my county even if I have to price your freedom out of reach. Is this tough love war, a judge stepping beyond neutral arbiter into probation officer mode? Let me know what you think.
If I can, Judge, I don't believe there has been actually any evidence presented to warrant a
Hold
bond
on, Stephen.
revocation.
She told me yesterday that there had been multiple threats.
So, all right, to circle back, there's a couple things. In speaking with pretrial, I have not received any information about threats. I've received information about cursing and rude behavior.
Yes, Judge.
Don't
There was
speak.
no threat of harm or anything like that. It was just more so attitude. He was making people in our office a little bit uncomfortable just with his demeanor and the things that he was saying, but none of it, to my knowledge, has been anything, putting anyone in danger, threatening danger, anything of that sort.
This is where I want.
Have an open.
Here's the friction point. The defense challenges the basis for revocation, arguing there's no admissible evidence presented and that rules of evidence should apply in a proper bond revocation hearing. Meanwhile, pretrial services walks it backed. It wasn't violent threats, but demeanor, cursing, and making staff uncomfortable. That's a huge difference, and the defense knows it. The judge, however, reframes it as respect, humility, and compliance, and warns of lighting him up like a Christmas tree. Legally, many jurisdictions allow hearsay in bond settings, but defense lawyers often fight for stricter standards when liberty is at stake. Question to the audience: should courts be able to use behavioral concerns and hearsay to restrict freedom pre-trial, or should they be forced to prove violations with strict evidence?
Hey, Judge.
So tell me what he tested positive for.
It was THC and alcohol, Judge.
This is where I will add that the court added bond conditions yesterday, so He had the
I
magistrate.
understand.
Okay.
He did have
So-
these magistrate orders, in October, that I did see that he was instructed over. It didn't have no alcohol, but it did have.
October what?
October.
14th, 15th. probably.
Give me the last name again.
Bledsoe, BLED.
Oh, no. He's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs and he tested positive right now, give me the date, please. Come up, Mr. Bledsoe. You're not off the hook yet.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything being heard by the court.
What day was the magistrate condition for no using, please? October 20th.
I'll also give my spiel about THC seltzers that I could buy at Specs that have no alcohol but have THC in them.
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be, you will stay with me. Do you understand?
Yes, sir.
Get whatever records you need. But if you test positive for THC again,
Yes,
you're
sir.
on notice now. You will stay with me.
Yes, sir.
Okay.
Now the drug test twist. The judge hears the defendant tested positive for THC. Despite being under no alcohol, no illegal drugs orders since October 20th, she gives him 2 weeks one last test. One last chance. Notice how she mocks the Delta 8, Delta 9, Delta 352 distinction. She doesn't care if it's technically legal retail hempif. The bond says no THC, then no THC. This is where a lot of defendants trip up, confusing what's legal to buy with what's legal to consume while on bond. It's not the same. If you're under court supervision, the judge's conditions are the law for you. Viewers, should defendants be punished for THC use when the product is legal, or is the judge right rules are rules when you're out on bond?
Thank you, Judge. Have a seat back in there. Come on. But did you have a preference on the reset date, Judge?
2 weeks, whatever you want.
Oh, I'm sorry, you're right. You said
And
2
I'll
weeks.
test him back.
So where do we land? A defendant with multiple recent charges: felony assault October 17th, terroristic threat, and evading faces, a judge determined to protect the public. Cap his freedom with strict conditions and yank his bond the minute he slips. The defense raises valid due process concerns, pushing for a proper evidentiary hearing instead of courtroom warnings and hearsay. The judge, meanwhile, sets a 2-week THC retest that could decide whether he walks back out or stays. Bigger picture, this is what pretrial freedom looks like when public safety, judicial discretion, and defendant rights collide head-on. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.